Straight ahead on Law and Crime Daily, defense attorneys for millionaire real estate heir Robert Durst request a mistrial due to his failing health.
Having Mr. Durst go through this trial is a serious risk to his health and even his life. We need to stop this.
The fireworks in the courtroom as friends of Susan Berman testify she revealed information about the disappearance of his missing wife. And the list of requests made by defense attorneys for the doomsday mom before Lori Vallow Daybell is moved to a mental health facility. Plus, the deadly argument over a mask at a Georgia supermarket. The 30-year-old veteran officer wounded after one. That's the word from the judge in Robert Durst's trial as lawyers for the real estate heir says his health is deteriorating. Anjanette Levy is here with the arguments and testimony about what the victim might have revealed.
Brian, Robert Durst's attorneys have repeatedly asked for a mistrial. They say that his health is failing and he seriously cannot assist with his own defense. But it's not the first time that a dying defendant has stood trial.
Susan Harmon and Susan Berman knew one another since they were children. Harmon told the jurors about a call she received from Berman in the early 1980s.
What could you tell from tones of voice?
Uncharacteristically confiding in me. Like, just, I got to tell you this.
Harmon revealed what Berman said.
She said that her friend Bobby had had a fight with his wife. She didn't know what she was going to do. If there was something, she said, I don't know what I'm going to do. And I was like, what you're going to do? He'd had a fight. There was an accident on the stairs and that she had to do something.
She recalled the decades-old call shortly after attorneys argued about Durst's medical condition. He sat in a wheelchair in jail clothes, unable to dress himself, wearing a catheter for a urinary tract infection and sepsis, a blood infection. His lawyers say he has end-stage renal disease and needs dialysis.
The admitting doctor at LA County USC Hospital described him as an ill-appearing cachectic male. Cachectic means a dying person.
But Deputy District Attorney John Lewin argued against further delay, saying Durst has planned to feign dementia and use COVID to get a mistrial.
Getting catheterized is no fun. I myself had a catheter for an entire week going in and out of court. It was not pleasant. I, in fact, recognized had the same size one Mr. Durst has, which was under my clothes.
Judge Mark Wyndham again denied the request for a mistrial.
Mr. Durst is a human being. I am a human being. I am not callous. It is not easy for me to require him to endure any pain.
Wyndham cited California case law.
The trial court is not obligated to suspend criminal proceedings. Rather, the proceedings are to be conducted in a manner that reasonably accommodates the special needs of the accused.
So how sick does a defendant have to be to delay a trial? We looked into it, and trials for war crimes involving Nazi guards have moved forward, with the accused brought into court on a stretcher. In one case, a defendant had an IV during a trial. Attorney Nafiz Syed said a trial can move forward despite a defendant's advanced age and illness.
We saw this time and time again in the War Crimes Tribunal, particularly because many of these war criminals were in hiding for decades. And by the time the court was able to find them, they were older. Many of them had suffered from various illnesses, and they used that time and time again to delay the trial.
For now, Durst's trial will go on, with witnesses testifying that Susan Berman confided in them years before she died about helping Robert Durst cover up Kathie Durst's murder.
She once told me that she called Albert Einstein Medical Center for him and said she was Kathie.
Now, that woman was named Linda Ops. She was a very good friend of Susan Berman, and Durst's lawyers questioned why it took her so long to come forward with this information. Then prosecutors called other witnesses, including Ops' lawyer, to back up her claims. Brian?
Thanks, Anjanette. Joining us today is criminal defense attorney Julie Rendelman and Terry Austin. Julie, Durst seems mentally there, but by the looks of it, he looks like he's almost on death's door. What do you think about continuing this case with his current condition?
Look, he certainly does look like he's on death's door. At the same time, I think we could all agree that he still seems to be participating in this in his defense. He's writing notes to his attorneys. When the judge asks about his catheter, he's the one lifting up his catheter to show that it's there. So the issue is whether or not he's able to engage with his attorneys and actively assist in the representation. The problem I have is if he's in pain, if he's in some way out of it. At one point, someone said that he was sleeping at the table. That is not someone who is assisting their defense. That is not someone who's engaged. And I do wonder, what is the point in time when we take a break and say, you know what, his medical needs need to come first, even though potentially he's committed these horrible crimes?
He's still presumed innocent, and the question begins as, what do we do with individuals in this state? Terry, loyal, manipulative, and perhaps in love with Durst. Are Berman's friends painting her as the perfect accomplice to Durst's crimes, or just a really good friend?
Well, look, there's no question that she's a really good friend of Robert Durst, but I wouldn't call her an accomplice necessarily. Look, if in fact she made this phone call to Albert Einstein Medical Center pretending to be Kathie Durst, I would label her an accessory after the fact. I mean, for that, all you have to do is show that someone assisted and it was after the crime and they had knowledge that the person committed the crime and they were intending to help the person avoid arrest. So we could call her that, I suppose. And we certainly have heard multiple witnesses talk about the fact that this call was made. Susan Berman felt guilty about that. So maybe she was an accomplice after the fact.
Absolutely. And Jeanette, Julie touched on it in just a bit, but what's Durst's demeanor been like in court since he's been treated for the latest illness?
You know, it did appear at one point during the latest arguments over his medical condition that he was engaged in listening to that. And then at another point during testimony, it did appear that he possibly nodded off, that he had fallen asleep, and his attorney, David Chesnoff, went over and spoke with him. And then after that, he turned around and very wide-eyed looked at the jury and was kind of sizing the jury up. So he appeared conscious and alert. It's whether or not, you know, everything else going on is impacting his ability to help with his defense.
Yeah, seems alert at points, but not consistently through the trial. And I think that's the question that Julie was really trying to hit the nail on the head there. Thank you, everyone, for your participation. Still ahead on Law and Crime Daily, jury selection is underway after nearly a decade of waiting for justice for the family of a murdered 13-year-old boy. But first, Lori Vallow Daybell to be moved to a mental health facility after being indicted in the murders of her 2 children. The lengthy request made by the Doomsday Mom's attorney next. Welcome back. Attorneys for the so-called Doomsday Mom are sending a long list of demands to the court now that Lori Vallow Daybell is officially declared incompetent to stand trial. Attorney Mark Means is claiming in court documents that Lori Vallow Daybell is in a fragile mental state of incompetency as a direct result of the historical and systematic mental, emotional, and physical abuse she suffered. Lori, along with her husband Chad Daybell, are facing murder charges in connection with the deaths of her 2 children, JJ Vallow and Tylee Ryan, and the death of Chad's first wife, Tammy. Chad is pleading not guilty, while Lori's case is on hold for now. Means was requesting all conversations about Lori's treatment, including apparent talks between the Idaho Department of Health directors and prosecutors. He's also asking the judge for private and confidential access to his client. In addition, Means is requesting to be directly involved in her treatment for the names and credentials of all people involved in her care and the medication and proposed plans. Lori is scheduled to receive mental health care for the next 90 days. If she's deemed competent after that time, proceedings against her will resume. If not, her time in the facility will be extended for 180 days. Back with us is criminal defense attorney Julie Rendelman and Terry Austin. Terry, this is a lengthy list of demands from the attorney. Is he able to even ask for these, yet alone get them?
Well, you know, medical information is as personal and confidential as it gets. And in fact, you have to have an authorization under HIPAA to get that type of information. It could be he wants to know the medications because he wants to determine how the trial is going to proceed when it does proceed after she's deemed competent at some point. But if he's asking for this information to make medical decisions, he has to get a proxy to do that, some sort of medical proxy, so that he has the right to make those decisions. And, you know, at this point, those types of proxies are usually just for family members, But really, in my opinion, he may be the closest person to her right now. And if he does get the medical proxy and an authorization, I think he's going to have to make sure he makes decisions in her best interest.
Yeah, and Lori may be able to give those permission to him. Julie, break down what's going to happen to Lori Vallow now, and will any of this be heard in front of the jury?
So it's a great question. So, she's been found unable to go forward with regards to assisting in her defense. And the job basically is to get her to be competent. Can they give, whether it be drugs or any type of assistance, therapy that allows her to be healthy enough to proceed to trial? Now, the question really is, there's a separate issue, whether or not they're going to use any of that in her defense. Now, as we know, that state, I believe it's Idaho, does not allow for an insanity defense. However, it does allow for any type of mental health issues to potentially negate her intent. And so there's so many questions. The first question is, well, if she becomes mentally healthy, is she perhaps going to at this point cooperate against Chad Daybell? That's always a possibility. And the second issue is, if she's not, is she going to use this mental health issue to somehow mitigate her behavior with regards to the crimes of which she's charged?
Interesting possibilities. They're definitely excited to see how that plays out in the next 90 or 180 days based on her mental health status. Jury selection continues in Colorado for the father accused of murdering his son during a court-ordered visit. 13-year-old Dylan Redwine went missing over the Thanksgiving holiday in 2012. In 2017, a grand jury indicted Mark Redwine for second-degree murder and child abuse resulting in death. According to court documents, Dylan reportedly found compromising photos of his father, including him wearing women's clothing and eating feces from a diaper he was wearing. Opening statements are expected on Monday, June 21st. Coming up on Law and Crime Daily, how an argument over wearing a mask in a grocery store apparently led to a deadly shooting. Plus, the disturbing case of two sisters raped at a daycare center and the strong words from the judge at sentencing. A powerful reminder to all. We're back. A judge in Ohio sentenced an elderly daycare worker to 22 years in prison for raping two young girls. Law and Crime founder and host of the A&E series Court Cam, Dan Abrams, has the emotional victim impact statements.
Our next stop is inside Franklin County Common Pleas Court in Columbus, Ohio, for the sentencing in the disturbing case against 70-year-old Terry McFadden.
You will be a Tier 3 registrant for your lifetime with in-person verification every 90 days.
2 months earlier, McFadden, who worked at a residential daycare business run by his wife, pled guilty to 2 counts of rape. The victims were attendees of the daycare, 2 young sisters, only 4 and 6 years old at the time.
Terry McFadden is a psychopath who raped our girls, fooled us, fooled 25 years worth of families in his wife's daycare. He's a skilled pedophile and a sociopath.
After an emotionally charged statement from the girl's mother that had McFadden shaking his head, Judge Julie Lynch also gives him an opportunity to speak prior to sentencing.
I apologize to the victims, to the 2 little girls. I hope to become to work to become a better person and when I have served my complete sentence.
But McFadden's apology falls on deaf ears.
This court is so sick and tired of seeing adults ruin and abuse children. These are literally just one step from being babies. They come to a daycare, those parents struggle so that when they release their children to someone during the day, they have some semblance that that child is going to be protected and safe. Not let alone 2 of their children being raped by your own admission, sir. For sexual gratification, you violated a 4-year-old and a 6-year-old. I do not know at this time what the total ramifications will be for those 2 young children, but there isn't anybody who doesn't understand now the developmental phases of children take place from 0 to 6 years old. You can't even know what damages you've done for sexual gratification. This to me is so mind-boggling that you used and abused two little children like they're inconsequential beings. Those are human persons with human dignity. I'm going to tell you something, Mr. McFadden. There's no free rapes in my courtroom.
And with that, the judge sentences McFadden.
On count 1, I'm sending you to prison for 11 years. On count 4, I'm sending you to prison for 11 years. They will be consecutive to each other for a total of 22 years.
The horrifying case comes to an end. But before dismissing the court, Judge Lynch issues one last powerful reminder to all.
Folks, if you see it, you smell it, you know it's happening, you report it. And this ends in this courtroom. That'll be all.
Powerful statements by the judge. When we come back, why 2 teens are now behind bars for a mass shooting. Welcome back. An off-duty deputy is recovering in Georgia after a triple shooting over wearing a mask in a Georgia store left a cashier dead and the deputy and suspect injured. The Georgia Bureau of Investigation says 30-year-old Victor Lee Tucker Jr. was checking out of the store Monday afternoon. Tucker is accused of getting into an argument about his mask with a female cashier. Officials say Tucker left without paying, then immediately returned. According to reports, Tucker pulled out a handgun and shot the cashier. The DeKalb County Sheriff Department says an off-duty veteran police officer was in the store and returned fire.
We had a subject enter the Big Bear grocery store, which is in the parking lot of South DeKalb Mall, County Road. There was some confrontation, not sure exactly what, in reference to the wearing of a mask. Each time the subject pulled out a weapon and shot the cashier at the location. The individual was deceased, and the officer, an off-duty officer, 30-year veteran off-duty officer that retired from the DeKalb County Police Department and reservist now with the DeKalb County Sheriff's Office, working in turn retrieved his weapon, pulled his weapon, and started firing at the subject. That officer was struck twice, transported to Atlanta Medical, where he is in stable condition, and the suspect was struck a couple times, has been transported to Redwine Hospital at this time.
Julie, the investigation is still ongoing, but an alleged murder over a mask? Is this a senseless shooting, or could there be something more?
I'm guessing there's nothing more. Look, I mean, both of us, handle homicide cases. I did for 15 years. People got killed because they gave someone the wrong look. So it doesn't take much sometimes for someone to react the way they did. Now, there seems to be some indication, although we'll know in the future, that he potentially had some mental health issues, which just goes back to the issue of you put a gun in the hand of someone who has mental health issues, something tragic is going to happen. But it'll be interesting to see what the additional evidence is that explains why this horrible incident occurred.
Absolutely. We'll continue to watch that case as facts develop over time. Thank you. Now to Florida, where 2 officers are being credited for their quick thinking for rescuing a special needs child from a canal. Police in Palm Beach Gardens received a call Friday morning of a 12-year-old running towards a lake. When they arrived, the boy was in distress in the canal. Police say the child was treading water but began to struggle. Without hesitation, the officers made their way into the water. Body cam video captured the officers saving the boy from possibly drowning. And in Texas, 2 suspects are under arrest for a mass shooting that killed 1 person and injured 13 others in downtown Austin. Police say a 17-year-old was taken into custody at a high school along with another minor. The 17-year-old is being charged as an adult. Shots rang out early Saturday morning on June 12th. Investigators are canvassing to determine how many bullets were fired and are looking for video and photos of the shooting. The Austin police chief says the incident appears to be isolated and most of the victims were innocent bystanders.
As EMS made their way through the large crowds, officers did not want to delay care, and they actually began carrying victims from the immediate crime scene, and in some cases, they transported those victims in their police vehicles so not to delay that care. it was clear as people were running out of that scene, our officers were running in.
Terry, now because of the suspect's ages, there are some things we know and some things we don't. Can you explain?
Well, one of the suspects is 17, so that one will be tried as an adult, but the other one is under 17, and so anyone under the age of 17, their records are not subject to the public. And what the state is trying to do here is not to criminalize juvenile misconduct. They want to try to promote rehabilitation of the child, so they're not making those records public. They're trying to make sure that the individual has an opportunity to do better in life and not have a record against them. Ultimately, though, Brian, the DA is going to decide whether or not this individual who's under 17 should be tried as an adult or a child.
Interesting to see how that plays out and what the ADA decides. Terry and Julie, thank you very much, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.